Hi, good afternoon. Welcome to the Cleveland Metropolitan Bar Association's Hot Talk. We are delighted to be welcoming people here at our conference center, as well as on Zoom and on Facebook Live. My name is Becky Ruppert McMahon. I'm the Chief Executive here at the Cleveland Metropolitan Bar Association, and we're delighted to have you join us today. We are actually just starting our 7th year of hosting these Hot Talks. They were designed to be conversations on issues that are really in the headlines and that people really want to talk about now. We oftentimes put them together very last minute as issues are hitting the fan, as they say. Today, we are taking on one of the most important conversations, continuing efforts to improve our criminal justice system in Cuyahoga County. The panel we've assembled is outstanding and second to none, as is our facilitator. Let me just remind everyone who's joining us here at the Cleveland Metropolitan Conference Center, we will be taking questions about midway through the program, so if you'd like to come forward and use the microphone that's at the front of the room, you are welcome to do so. If you're joining us on Zoom, please use the chat Q&A or chat feature to offer your question. Our team will be monitoring those questions. And if you're joining us on Facebook Live, you can do the same thing. Use the comments feature to put your questions. We will be fielding every and all. We'll get to as many as we can, but let me just apologize in advance to say I'm sure we won't be able to get to every question that's presented. Our conversation today is teed up for 60 minutes on the dot, so we will be wrapping up right at 1 o'clock. And with that, let me introduce our facilitator. Our facilitator today is John Mitchell, who's a long-term friend of the Cleveland Metropolitan Bar Association. He happens to be a member of our board of directors currently. He is also one of the co-chairs of the Judge for Yourself coalition responsible for judicial ratings. John recently moved to the Taft Law Firm, where he is a partner who brings a tremendous amount of experience both in the criminal and the civil arena as a litigator. He is, I might add, for this conversation, he spent plus years as a Cuyahoga County prosecutor at the beginning stages of his career, where he was in the major trials division. So he is really an informed expert who's going to be leading the conversation today and introducing our panel. John, everyone, thanks for being here.
Thank you, Becky. Good afternoon, everyone. I am really pleased to be the moderator today, and I'm excited about the panel that we have in front of us that will be addressing these issues. Simply put, I think we've got the key stakeholders who are going to be guiding this project going forward. And I'm not going to spend a lot of time on introductions because I think the substance is more important. So on the far end over there is Judge Brendan Sheehan, who is the presiding and administrative judge of the Cuyahoga County Court of Common Pleas. Next to him is Judge Michelle Earley, the presiding and administrative judge of the Cleveland Municipal Court. Next to Judge Earley is our county sheriff, Christopher Viland. And then last but not least, the individual who forgot his clip-on tie is Bob Coury, our our public safety chief for Cuyahoga County. The goal here today is to really address concerns that the general public has about how the central booking system is designed and how it's going to work. So we're putting tremendous time and energy into making sure that we hear your questions and your comments. So as Becky started by saying, this is a hard and fast stop. We are going to hold presentations generally to about half an hour so that we have plenty of time to hear from you and to address questions that have been directed to us. So I believe the way that this is going to unfold is that Bob Coury has a PowerPoint with him today. The other members of our panel will be contributing to that PowerPoint so that we get a broad overview and an understanding of exactly what is being offered in terms of what our central booking system will look like. So Bob, I will turn the floor over to you.
Thanks very much, John. I appreciate it. So I'm going to dive right in, but first I'm going to tell everybody what we all know. In order to understand central booking, you have to first know that it fits a small piece of the criminal justice process. So the criminal justice process begins when an individual is arrested or they receive a summons because a police officer believes they committed a crime, whereupon they're taken to jail, whereupon at that point they could be charged. They could be charged with a misdemeanor or a felony. After that, they need a first appearance within at least 48 hours in order to get a bond or have the opportunity for a bond. We then know that if it's a felony, their case will be presented by a county prosecutor, most often to a grand jury. Once the indictment is received, or the true bill indictment, because the grand jury believed there was probable cause, the Case is then set for pretrial in common pleas court. Pretrial activities and shenanigans occur. The case may go to trial. The trial then ensues. And in the case of a conviction, what comes next? Of course, sentencing. After sentencing, there's things such as post-conviction relief, etc. So what is central booking? Central booking focuses on that narrow equation from beginning of arrest, just before arrest in the case of Cuyahoga County central booking, through the first appearance, where within that 48 hours, but less, that's the goal, an individual will have the opportunity to be represented by counsel and receive a bond so that release can ensue wherever possible. So what is central booking? Then all of the stakeholders that you see up there or over there, depending upon where it is on your screen, all of these individuals then got together, I want to say about April of last year, after all the legislation was done, the budgeting, et cetera, and we began to work in earnest collectively together on developing all of the processes that would involve in central booking. That includes our memorandum of understanding. And you can see from it that it focuses, it's inmate-centric, making sure that the process during these things are fair, that we take the opportunity to divert and use our shiny new diversion center to divert the inmate wherever possible from the criminal justice system to the diversion center where things like mental health and drug court can be treated, and that they're provided counsel at the earliest convenience, et cetera. And we took some time to come up with this memorandum of understanding because we knew it was going to be the basis for our criminal processes. Quickly, this goes back to 2005 and before that. Back when dinosaurs roamed the earth, and our sheriff now was a Solon police lieutenant, and Judge Sheehan, Judge Earley, and John Mitchell were all assistant county prosecutors, and I was the first assistant county prosecutor, and you got to boss them all around. Back then, even, we took a shot at criminal justice reform, including central booking. And we knew at the time that it was the right path, but it did not get traction. And I believe it was because, or we believe collectively, that it was because it might have been too top down. You know, we got the consultants and we pushed it down rather than getting buy-in from the stakeholders. Well, we've rectified that, and the stakeholders have been from the ground up involved in this central booking program, including developing the memorandum of understanding that we're all proceeding upon.
You know, Bob, if I could, you're walking into literally my very first question for you. And when you describe the involvement of other stakeholders, what I have in mind are the judges, the criminal defense bar, police departments, municipal prosecutors, municipal courts. Can you tell me what involvement those entities have had as stakeholders in turning and developing a central booking system?
So we've been meeting since April, as I said, where each of the individuals identified their processes, looking at the same time at our map based on best practices. And we'll book through some best practices slides. We based it on our consultant DLR, who provided us information on all the best practices throughout the county, and then each of the stakeholders from Cleveland Municipal Court all the way through the county administration and victim administration, all through these stakeholders had the opportunity to imprint their view of central booking. As I said, that included what they believed the objectives were. That's the goal. But also to make sure that we're making the best charging decisions, bond decisions, and perhaps decisions about which specialty court that they could go to as early as in the first 4 hours, because we'll have pretrial services reviews by common pleas and municipal court for the first time working together.
Bob, I think, yeah, Chief would like to weigh in.
Yeah, I just really quickly, part of your question, John, had to do with local municipal courts, clerks, and police departments. And just for clarification, I want people to understand that this first phase of central booking is primarily the City of Cleveland Police Department, City of Cleveland Clerk of Courts, and Cleveland Municipal Court, along with the county courts, and some of the very few municipalities that we have contracts with to provide housing in the jail. The plan eventually is to expand it to more and more places, but right now it's more of a centralized phased approach.
Thank you, Sheriff. Judge?
Also, what we did under Bob Coury's leadership, there are a number of places in the process to where either it was not going to look like a typical centralized booking where you might find somewhere else in other jurisdictions. And instead of allowing that to be a place where we would stop and not move forward, as probably is what has happened in the past, we got to a place of, well, what do we need to do to make it work? And I think that having all of those meetings allowed us to, as a group, continue talking about, if we're talking about charging and the prosecutor's office is concerned regarding the victim's advocate input, then we brought that group in, and that kind of made it helpful to push forward by bringing all of these entities, and the list just kept growing in terms of the stakeholders, and that's kind of where you have now to where, you know, we have a lot of people at the table so that, you know, some of the roadblocks that we've historically had, we were able to kind of push through those.
Thank you, Judge.
So, mounting on what the sheriff said, this slide's important because I'm going to quickly go through what currently in Phase 1 central booking does not include or is not. It does not include yet the suburban district courts and the suburban police officers. The focus in Phase 1 is on Cleveland Police Department and their arrest process, and as the cases move through that, arrest through first appearance. Why is that? They represent the majority of cases anyway, and we wanted to make sure that we could walk before we run. One of the mistakes that were made in 2005 is that when we tried to do the process, it included the entire county, and it became initially unwieldy. We're not going to make that mistake again. Let's roll it out. Let's get it perfect for Cleveland. People like Judge KJ Montgomery at the time, before she retired, all endorsed that process. They said, you guys make it work, and then let us look at it, and then we'll come on board.
So Bob, you raise an interesting point, and I don't know if you're doing this on purpose, but you're literally walking right into my question. So here's number 2. Mindful that the goal is to get Phase 1, I think you described it, walk before you run. Understanding there are more than a dozen municipal courts in Cuyahoga County, and I haven't been in all of them as either a litigant or a defendant for that matter, but I would say that it's my understanding that each has its own processes, their own procedures, their own IT systems, their own way of doing things. What would be the plan to assimilate these many competing courts into the central booking system?
I have no idea. And if you...
Well, honesty is appreciated. Go ahead.
We obviously had and invited the municipal courts to the process in the beginning. And you just pointed up all the hurdles with trying to do an implementation of central booking, including the construction, including the layout and design, including how police officers will pull into the Sally Port. And you're raising all the issues that has to be resolved in Phase 2. So I would be exaggerating if I said that we had a handle on that, because we don't. Are they going to want to present their cases directly to the grand jury? Are they going to want to arrest and charge and then go through their municipal courts? Are we going to have a situation in which some will have municipal court first appearances in their jurisdiction, or other police departments will bring them directly to the county and then do direct criminal presentations to the grand jury? These things have to be determined, and hopefully consistently across the municipalities, but maybe there'll be nuances across each of them.
Thank you.
So I'm going to, as I said, I'll book through the timeline. So we started the process in earnest back in August before I was with the county, and then all the way through today, and then we plan on going live with central booking May 1st. Construction will be completed, and we'll have our first inmate come through central booking. That's the plan. Right now, we're in the middle of, not in the middle, we're near completion in construction, but we plan on being done soon. So the existing situation, the sheriff's going to talk about what the problems are quickly. And the sheriff, I pulled up that slide so that you can understand all of the problems with the current infrastructure and some of the basic reasons, without any of the innovations as to why we need to do this. And with that, I'll turn it over to the sheriff.
Yeah, so as Bob said, I'm just going to talk to you a little bit about physical plant, why we are in the situation that we're in, why the booking intake processes could be improved regardless of whether there is stakeholder input or phase two eventual encompassing of all the municipalities. I think we all know that the Justice Center is old. It's archaic. When it was built, especially the jails, they did not take into account things that are current technology. For example, they didn't take into account the fact that we do electronic fingerprint scanning. They didn't take into account the fact that we have full body scanners. They didn't take into account that we have to do a full confidential medical screening. None of those spaces were built. They don't exist, and where they exist now, they've just been shoehorned in. This has led to a workspace that's just difficult for people to work in. Incoming law enforcement officers do not have room to prepare their documents to incarcerate or charge. There's no room for this to do that, or there's no room there for them to do that. That means that oftentimes they have to leave the facility, go back to their home districts or their home departments, complete paperwork. That adds delay to any forward progress that an inmate may make. There's no current place in intake where any stakeholder can have contact with an inmate. Pretrial services, any assessments or defense counsel access just doesn't exist. Again, until we get them to a place where we can integrate those stakeholders, it just slows down inmate movement through the criminal justice system. As I said, confidential medical screening absolutely does not exist at all. So it results in a huge loss of privacy. But as we've seen over the last 2 years, it also has a huge effect on us when it comes to infection control and isolation. One of the things is people walking in the door, current intake, everybody's together. And so infection control is an issue. As in many older facilities, there's just simply not space to hold inmates in a place where the process could be moving along with them until we have to actually move them into the general population. We don't have the flexibility to maintain a holding area where processes could occur. We're forced to push inmates up into general population relatively quickly. And again, once they're in general population, access goes down and our ability to quickly move these people through the process is reduced. So the central booking construction and workflows that are going to be in place with the addition of the stakeholders who will have active act points physically, hopefully will make the process of moving an inmate through the justice system speed up significantly. That's the initial goal before we go to a larger scale phase two.
Thank you, Sheriff.
So what does contemporary central booking look like? So what does it do? It focuses on improving those processes from the arrest through that first appearance. It provides the opportunity for initial reception improvements, including the possibility for diversion back out of the criminal justice center, back out of the criminal justice system. Perhaps that person could be diverted to our diversion center or other treatment services as necessary. There's a nice airport open waiting for individuals rather than immediately putting them in there, putting them in their oranges and putting them in cells so that it's a more relaxed environment. It provides for the opportunity to have court services right there in central booking for a municipal court, pretrial services, common pleas for the first time, pre-bind over, before it goes to common pleas court, interviews by pretrial services, and you need a facility to do that. So it's been proven successful throughout. I mean, we had the experts tell us that we had virtual surveys through during COVID at Harris County in Texas, and it's been proven successful in many places. So we're not reinventing the wheel. So why are we doing it now? We're doing it now instead of waiting for the new jail, because as I've said before, and others agree, justice delayed is justice denied. So with the opportunities to do this now, there are inmates today that can have better outcomes, right? And less days in jail.
Thanks, Bob. So let me stop you for a moment. One of the things that the city of Cleveland, the Cleveland Municipal Court has been a real leader on is the idea of bail reform and getting people in and out so they don't suffer adverse job consequences. They can be with their families. So I'm going to address kind of to Judge Earley and to Judge Sheehan, respectively, in the Cleveland Municipal Court and also in the Cuyahoga County Court of Common Pleas. Can you tell me how you see the central booking, I'll call it phase one, as it's unrolling, how that's going to affect the bail reform process and what impact it could have on a person who finds himself arrested and potentially charged with a crime.
So in Cleveland Municipal Court, with the pretrial services that we have and the department that we currently have, we have someone who's there from 5:30 in the morning until 1 o'clock at night. So that when someone comes in and actually oftentimes we're interviewing them before they're charged, so that if they are charged, we're prepared for them to come and be on the docket. Having centralized booking will assist for Cleveland Municipal Court because, as Sheriff Viland indicated, it gives the officers a place to do their paperwork. So in terms of potentially having to go back to the district to get charging paperwork, or for detectives to have delays and having access to individuals to charge them, that charging process will be quicker. In Cleveland Municipal Court, the docket is open until 1 in the morning. So if someone drops charges off at 1 o'clock in the morning, and that if person's arrested and they're charged by 1 in the morning, you get on the 9 o'clock docket. So, and we're doing court Monday through Saturday. So there's only 1 day a week that we are not doing court. So this centralized booking will assist having people not sit in the jail unnecessarily. And it will assist in our pretrial services. Obviously, it's giving us a option to do charging or to do making pretrial release decisions, and having our staff there able to do it quickly as the officers are charging quickly, and having a place where the jail isn't being compromised, because we want our people to talk to the individuals. They're giving us space to do that, giving the police space to charge quicker. Victims advocates are also there, so we can, the staff can talk to the witness victims. So all of that, having all of that process in a place where it can be done quicker assists us in getting people into the courtroom faster. So, the hope is that typically we're doing around 36, 48 hours after arrest. Maybe we can do less than 12.
Thank you. Judge Sheehan.
So, yeah, first of all, Judge Earley and it's fun to be working with the same people you worked with back in 2005. And by the way, I knew Bob Coury when he used to wear ties and had really dark hair.
And I can
and
say
Judge
for the,
and John Mitchell, who had dark hair at
you were
one
a
time.
brown-haired, handsome man. It's the same as...
Judge Russo, if you're listening, I joked with Judge Russo when I started this job. I said he lost his hair when he was administrative judge. I think I'm on that fast track with him. But it's funny, if I can just weigh in a couple of things here. First of all, it's amazing. I'm sitting here today, and I was thinking about it 2 years ago. I was sitting in a judges meeting talking to our judges about COVID and when it's going to hit and how we're going to deal with the jail crisis and how we're going to reduce the jail. And here it is 2 years later, and we're talking about something that is something to continue the process, is the central booking. And I want to compliment Bob, the county stakeholders, for all they've been doing. I mean, I can tell you, being with Bob Coury on weekly meetings is just unbelievable. And he does a great job organizing. But one of the things, our goal with central booking with the county and how it will affect the bail is, first of all, we are moving our services that our court already has, which is pretrial service officers, bail investigators, GPS unit, to the very front of the system in central booking. And the moment someone enters into the doors of central booking, we are having our folks there and are in that process. And it's great working with Judge Earley because we're coordinating with Cleveland Municipal Court's pretrial services on those cases that will be charged as felonies, so that we can have, one, an appropriate bond recommendation, and two, which is huge, access to GPS prior to the bind over into common pleas court. So we're developing our resources up front to help out. And when Judge Earley and the judges in Cleveland Municipal considering bond, we're offering at least our recommendation to them with GPS and our different monitors that we would think. The other thing that is huge in this area is it's going to enhance our services by adding special program eligibility screeners, mental health
That's
liaisons.
a great point. I want to you guys are really racking through my question.
Yeah, oh, go.
So
Yeah.
real quick, and whoever wants to address it can address it. So if somebody comes into the central booking process, they will have, I don't know if advanced is the right term, but almost immediate access to specialty dockets, drug diversion, things like that?
Screened by our specialties individuals and coordinating with Judge Earley. So if they decide, this is going to be a felony case, Judge Earley's investigators have already done their background stuff, and it's going to be able to expedite our process, eliminate duplicate work, and we're going to be able to get our screeners in there so we know if they can be a specialized docket, a MHDD. And one thing that was mentioned, it's kind of before they walk into that jail with a felony charge, there's another chance for us to communicate with the prosecutors. If our group sees this person and says, geez, maybe this would be a better person for the diversion center, we can walk down the hall to the prosecutor's office and the public defender who's there and say, have you guys looked at or considered this? So it's kind of a last gap before someone actually goes into that jail, which will be, we're hoping would eliminate a lot of people spending time in our jail.
Thank you. Bob, the floor is yours. Or Judge Earley, I'm sorry.
And also with the understanding that obviously we have a number of specialized dockets in the city of Cleveland, and the Common Pleas Court also has a number of specialized dockets, so our pretrial services officers are keen into determining whether or not someone is eligible for those dockets, but we also balance that with the idea that they may not want to be in the docket, and we know that research shows the quicker you can get them in the specialty docket, the better. But they may not want to go, and they may be not guilty. So we're also mindful of not shuffling people into different categories based on specialized dockets in terms of violating rights. So we make sure that we're understanding of the fact that the people have rights to remain silent, to not be guilty, and
They wanted public trial, right.
And have a lawyer. And we still can kind of flag that person as someone who may be eligible either now or in the future. So we have that ability, but we're mindful when we are having these discussions of that caveat.
Thank you, Judge.
So I'm going to go back a bit. I was on the pretrial services slides. So you could see that from this slide where the processes that the sheriff discussed, Judge Earley, Judge Sheehan discussed, are accounted for in the space itself. From the first opportunity that law enforcement will have to get their incident reports done before they ever leave central booking, and as the sheriff pointed out, that opportunity physically doesn't exist now. So we're gonna have the opportunity to get the first appearance report, which is the basis for municipal prosecutor decision-making, county prosecutor decision-making, so then when they're collaborating with regard to whether this should be charged as a felony or a misdemeanor, they'll have the incident report done. That will then allow the police officer to get back out on the street and do what they need to do to protect, to continue to protect the public. It'll provide space for those pretrial services interviews and the collaboration between municipal court and common pleas court on those assessments, because at our tabletop where we work through the processes, Ms. Pope Earley identified from hearing the processes that there were duplication of defendant interviews, inmate interviews, and there's opportunities there to ask the question one time, do you have any addiction issues, right? And then that information being shared. That problem, that issue was discovered as late as just last week. So Becky likes to call this our look at all the work we done slide. And I'm leaving it in because, yeah, look at all the work we done. So the most difficult part was not just mapping each of our individual processes, but the interdependencies was a bear, right? And by doing this, we were able to identify the interdependencies and then look for opportunities to either delete duplicate processes or to improve the communication in those processes. For example, what doesn't exist now is pre-charge collaboration between a municipal prosecutor and a county prosecutor, collaboration between pretrial services at both courts, and the opportunity for law enforcement to be able to communicate with not just the city prosecutor, but the county prosecutor as necessary. So interim central booking update on the processes. I'm going to turn to my colleagues to talk about from their perspective, what they feel the process improvements have been able to do for their court and for the sheriff department directly.
Yeah. I'll start off, Bob, and what I will share is that I often get blamed for the big tabletop where we had to put a bunch of people in a room and walk this through. But it's been my experience, and you saw the process map that we created where all the stakeholders' interdependencies and process flows were given, that if you put people in a place where you just ask them, are you going to be okay with this? Is this going to work? Very often you get answers from task-saturated people that is in the affirmative because they think it's going to work, and you don't get an opportunity to identify the failures in the plan. So what we actually did was we brought representatives of every stakeholders group into a large room with hypothetical inmate circumstances, and we physically walked a hypothetical inmate through each of the stakeholders' processes all together where everybody could observe what was going on. I think it was a great exercise. I think it was educational for people who only saw their part of the process sometimes to see the overall arc of what this central booking is going to be like. It gave people an opportunity who may see something from an objective viewpoint to raise an issue that people who were in the weeds didn't quite see. It gave people who were actually sitting at a table next to each other an opportunity to talk about how their communication needs to change or improve in order to make this effectuated the best way possible. So the process was long. It was onerous to put together the tabletop exercise, but I think the end results were that we ended up with a list of things that we still now need to do process improvement on or additional communication on, so that when we are ready to go live, it won't be the first time that any of our stakeholders participated in the process.
Judge Sheehan wants to add.
Just one last comment to that. Sitting through that whole tabletop made me realize how important technology, updating technology, and communication is. I mean, the fact that we had each department and each, from the officer to the sheriff, to each person asking the same person the same questions and the same, how technology can maybe expedite the process, and we can share this information from the minute that person walks in the door to the minute the person is looking at a bond review. It should be a quicker process, and that tabletop was the first one we had. I hope we do a couple more, and we can develop more snags in what we see. But I think technology is going to be a great asset to helping expedite people out of our jail.
Thank you. So we're about halfway through, just a little bit over, and I know Bob wants to get through, and I think it's important that he gets through his PowerPoint, and I just want to be mindful of the time because we are going to have questions from folks in the audience and through email as technology has given us. Oh, wow. That was
right on cue, Bob.
Yeah,
I love it.
Wow. I mean, I don't know that I'm going to have this success all the time, but anyway, please, is there a question?
Yeah, they're coming in from Zoom. So thank you everyone on Zoom who's been submitting questions. One of the first ones we got is more of a general question probably for the sheriff. Is there a tandem plan or coordination with law enforcement about using their discretion to not arrest someone if there is no risk of harm?
Yeah, so actually I'm going to defer this question to Bob because what we're talking about is the diversion center. But before the diversion center opened, in my past life in law enforcement, and since I've been appointed sheriff, when the diversion center opened, I think all of law enforcement in general took a deep sigh because law enforcement professionals for decades have been running across people who were in crisis, whether that be a mental health crisis or some sort of addiction, alcohol, drug-induced psychosis, whatever that is. And everybody unanimously agreed that these are not people who need to go to jail. Unfortunately, for the longest time, we as a society have not provided a place to adequately care for those people. They needed to be placed somewhere, and they ended up getting arrested very often for their behaviors. But since the opening of the diversion center last year, we are, and I'll again defer to Bob, but the diversion center is actively campaigning with local law enforcement to make sure that at the street level, where that discretion is first taking place and a determination is made as to what the disposition of that person should be, that those law enforcement officers are given the ability and discretion to divert those people directly to diversion as opposed to going to jail.
And to follow up, I mean, so what I'm hearing, and I think this again addresses a question I had laid out or somebody had sent me, is the idea that when somebody comes in, they can avoid a criminal charge through being sent to diversion. Is that accurate?
At this point, the way that the diversion center is set up, that if a law enforcement comes across somebody who's committed a nonviolent crime, somebody who's in a crisis state, and with the pre-approval of their legal and prosecutorial people in charge, they have been given discretion to take that person directly to the diversion center for the necessary treatment and stabilization, rather than just bring them to the jail, impose a charge on them, and then hope that a docket or a settlement helps
Somebody
them.
cleans it up later.
Exactly,
Right.
yes.
No, thank you,
Just
Sheriff.
to add to that, Mayor Bibb, when he took office, one of his first things he did is change the policy about the diversion center, and he's adamant now to utilize that diversion center. So we'll see, hopefully we'll see these numbers change.
Thank you. Questions?
Yes, we do. Will central booking affect the size needed for the new jail, i.e. decrease the size?
That gets into whether
Bob
or not
and I fight about this all the time.
So that gets into the metrics, right? How effective is central booking at reducing the jail population? While not the primary reason to have an effective central booking program, nevertheless an important one. Not the primary reason to have an effective diversion center, but nevertheless an important one, reducing the jail population. So it is our expectation that central booking, by reducing the time between first appearance and the original arrest, that the accumulation of jail days that will save, inmate jail days, will be sufficient to have an adequate impact on the overall jail days throughout a given year, and thereby reducing the jail population. Same with the diversion center. I believe, though, that the devil is in the production. So we're going to have metrics to apply to it, to how long it takes to process those cases through first appearance, and then when we go to phase 2, how much more quickly do we process cases, and then see if we can see that benefit, which is reduction in jail population. So we won't make promises we can't keep. The proof is going to be in the pudding when we implement this, and we'll see the impact on reduction in jail population. But it can only improve it. It cannot increase it.
And I'll just add on that one of the things that COVID did was make us reassess who would be in the jail. And when COVID originally hit back in 2020, there was a huge push to get as many people out of incarceration status as possible for everybody's health and well-being. And the population of the jail was artificially depressed. But as Judge Sheehan likes to give us numbers every week as we assess our jail population and ways that we can manage it better, what we have done is we have distilled the people who are currently in the jail down to those people who really shouldn't be out of jail. Of the judge's pretrial population, very consistently between 85 and 90% of those people are in for aggravated violent felonies above the felonies of the third degree. And those are people who just aren't great candidates for release in some way or another. So there is always going to be a core need to have a specific jail population when we build a new jail. I think we're in the process right now of, over the last several months, determining where our baselines are. I think that there will be, there's been a difference. Pre-COVID, our jail population numbers were very often above 2,200. We have settled in probably for the last 3-4 months, somewhere in the vicinity of 1,600 to 1,650. So our processes are better. We have more people out on electronic monitoring. We do a much better job of processing people out who shouldn't be there. And I think that we're developing data that is going to drive specifically what the population of a new jail will be.
Judge Sheehan.
You know, Sheriff, you bring back that. I think I have PTSD. 2 years ago today, that number was over almost 2,000 inmates in that county jail. I think it was 1,980 to be exact. And now, today, just so the public knows what that number is, it's 1,590 today. With which is, I'm proud to say, with the sheriff and our collaboration with working weekly meetings, daily meetings, we have 0 positive COVIDs in that jail. And everybody has been, I mean, just compliments to the whole team on keeping that jail population safe. But the numbers right now is at the 1,500s, and you know, who knows where it goes. Lower, hopefully, where we're at.
Thank you. So I saw on the PowerPoint a lot of construction drawings. Bob, you spent some time going through what are inadequacies in the system today. So I guess my question is, has there been an analysis of a cost-benefit analysis in terms of how this may save money or cost more money, or return on investment in terms of what the economics would look like to the taxpayer of imposing or creating a central booking system?
So we bought that, we purchased that cost-benefit analysis when the county, before I was there, had the foresight to get the experts, DLR, to tell us about the best practices and the ROI that Camden and Harris County, Texas saw from their investments.
Can you talk about that?
I can, but I will show you too that they did receive, they did in fact incur reductions in jail population, right? And when you look at, if you wanted to cost account an average jail day costs now about $130, Sheriff, $130 a day. So when you talk about reducing the jail population, and you'll see the Texas up there now, when you talk about reducing the jail population, using effectively central booking, for example, you can see how it's going to go right to the bottom line. So we're relying on the experts. We're relying on the fact that when we met with Texas, Harris County, Texas, and they took us through their process, that they received the same benefits, and we're following that best practice. So we expect to see an ROI. We significantly reduced the budget down from $7 million for this central booking project, from $7 million down to under $3 million, because we didn't want to spend so much money that is ultimately going to be duplicated when we build our new jail. But this process, all the experts said, needed to be done because you get ready for building a new jail. You understand what the jail population will be as a result of central booking. You identify your processes and get good at them so that when programming is designed for the new jail, it will be based upon the results that we had in our interim central booking project.
I would just like to add, though, that I do know that the county's done a lot of work with balancing what their investment is going to be and looking at what the ROI is, but it can't always be purely an economic indicator of success. We're looking at quality of life for the people who are coming into the system and best results as they exit the system. And sometimes the investment is more about doing what's right for them than necessarily saving a penny here or there. So that's always part of the equation, the way that we look at it.
Fair enough.
We had a follow-up question about the diversion center. I think originally there was a plan to permanently place the diversion center in a different location, and what's happened with that discussion?
So there was a diversion board meeting just last night, and as Judge Sheehan talked about, with the change in the Cleveland administration, came a new hope that the current diversion center would not continue to be underutilized by the city of Cleveland. They're our main customer for that, we believe, for that diversion center. So as the judge pointed out, with Mayor Bibb's administration, there has been an immediate emphasis on changing policies, specific written police protocols, and elimination of a city prosecutor requirement for review before that case, that inmate, that arrestee can be sent to the diversion center, right? So it remains to be seen if we can improve the utilization. The policies have been changed. Now we have to make sure that the rest of the Cleveland Police Department gets the crisis intervention training, that the supervisors that they have in place to get increased crisis intervention training can push down the culture to the police officer to not just default to take them to the jail and make part of the default take them to the diversion center. Then over the months, we'll see if that can improve the diversion center population, which will reduce jail population.
Next question.
There are more questions. What, if any, impact will central booking have on how prosecutors charge defendants? One of the recurring issues is whether prosecutors overcharge. As defendants are moved through the system more quickly, what will happen in general to charging?
You know, I don't want to speak for Prosecutor O'Malley, but I know from the meetings, him and his first assistant, Lisa Williamson, looks at central booking as an opportunity to have a conversation, a frank conversation with the public defender who's going to be there and talk about could we agree on some kind of reduced charge to make this, keep it in Cleveland, keep it a municipal court case rather than a felony case. And I know that they've had those breakout rooms, I guess, Bob, is that what we called it? There's little breakout rooms where they have those discussions that's in your slide. But it's, I do believe they're hoping that they can reduce and have some frank discussions there. Anyone want to add
And
on
for
that?
the city of Cleveland arrest, the city prosecutor will maintain reviewing that case like they do in all the other municipalities. So they will be reviewing that case and then having discussions about binding that over. So if there's a chance that things can stay in Cleveland Municipal Court or that things aren't charged, they still will be doing that.
And did I understand that there will be a dedicated public defender there to immediately address the issue of a
That's
right
correct.
to counsel?
So one of the things I booked through in the slides was that each of the stakeholders had to identify the resources required, which are always additional resources required to do the best practices. What does that mean? An additional public defender to cover a second shift, right? So that prosecutor can be dedicated throughout the day to central booking. The same with the city prosecutor. And the city has been struggled with finding the resources to do it, and just like the rest of the country, staffing issues. They're down in staffing and it's difficult to get candidates. The county prosecutor is committed to having a dedicated prosecutor, and the sheriff could talk about the facility if necessary, about where they will be housed on a separate part of central booking, so that the city prosecutor and the county prosecutor, by design, after the city prosecutor reviews the case initially, can consult on whether the case should be charged as a felony. That is included in there, and each of the stakeholders have committed to the necessary resources to be able to accomplish those tasks.
Thank you. Next question.
A follow-up to that, one of the delays in charging by Cleveland police officers, oftentimes officers either delay processing reports or delay sending the documents to the charging desk, where they then languish without complaints being timely filed with the clerk of courts. Has there been any improvement in the charging process with CPD?
Well, I'll go ahead and step in for my law enforcement brethren at Cleveland Division of Police. Cleveland Division of Police charging culture is probably fairly characterized by some of what was asked in the question. But I will say that working with them through the tabletop process and having weekly meetings with them about how process improvement and process change has to take place is, I think that there will be a change that is noticeable. We will be moving central charging directly into the stakeholders group on the third floor of the Sheriff's Department, right upstairs from central booking. So all of those stakeholders will be in the same place. Law enforcement officers will be downstairs completing the reports. Central charging will be upstairs having immediate access. And as with everything I've said before, it's all about timing. It's all about communication and moving that information quickly so that people don't, and I think the word was languish in the question. The goal is to prevent that, and from everything that I've seen, Cleveland Division of Police is well on its way to cooperating in that.
And
Please.
I'm going to weigh in on that as well. If someone is arrested, the judges of the Cleveland Municipal Court review a document, and anybody who has not been charged within 36 hours, we release. We do that 7 days a week. So, we're on top of that as well. And this is not a new process. We've been doing this for years before I became the administrative and presiding judge, and this is my 5th year. So we do that every day of the week, even Sundays, to make sure that if someone is in jail, they've been sitting for 36 hours, there is no charge, we order them released.
And there's no change to that process, correct, Judge?
No, absolutely not. And obviously with centralized booking, that we know that process can be updated, but we are involved in making sure that the law is being followed. And honestly, we have very few people that we have had to release. So I understand that that's someone's experience, but in terms of having to release them, from the beginning, Cleveland has been compliant with that.
Please.
Yeah, another one. It seems that a lot of defendants are being placed on GPS even when there is not a charge of violence. This often causes defendants to sit for a day or more after bail is posted. This seems to be unnecessary. Was this a policy decision made, and why?
That would probably fall to me, our GPS unit. What they do the assessment of the risk factors, the person's appearance rates, and then they present that to the arraignment room judge. And obviously, it's up to each individual. There's 34 of me. It's up to each individual judge in that arraignment room to decide if GPS is appropriate or not based on the arguments made in that arraignment room. I can tell you that one of the things we did during COVID was expand that GPS unit, and we have a lot of GPS units out there. I think we have over 1,000, close to 1,000 GPS units. Those are people who aren't sitting in our jail now, who are out in the community, who have exclusion zones and different things. And usually GPS applies to individuals where there's a violent crime or there's a victim or domestic violence, where they want to keep people away or out of the zone where the victim is at. And that's usually how it's applied, if that answers.
And we also have a GPS unit, but we only utilize them for domestic violence cases. But even still, we're mindful of how long people should be on GPS. So we have our pretrial services sending reports up to judges, letting us know how long people have been on GPS, whether or not they've been compliant, so that we can continue to have discussions to make determinations whether or not that's the least restrictive means of release. So sometimes they do need to keep the GPS on longer, but even during the process, we evaluate that on a regular basis to make sure that we're using the least restrictive means of detention.
And I would just follow up by saying very often people misunderstand being released from the county jail, and they assume that it's some sort of instantaneous process, which it's not. So even upon receiving an order to release on a GPS, having the GPS unit actually physically be able to go in the jail and do the installation, as well as having to contact any other stakeholder who's involved in the justice system to make sure there are no warrants that have come through the system while the person was incarcerated, or if perchance this is a person who's come back from the prison system and is now being released on GPS, we can't release until the prison system gives us an authority to release. So it's not an instantaneous thing because the judge has ordered a GPS that you walk out the door 5 minutes later. Sometimes that process is delayed. It just takes a bit of time.
And just to add, hopefully during central booking, if you notice, we moved that GPS up front, so a lot of those issues can be dealt with, so there's not a delay at the time that person gets arraigned. So that's one of our hopes during central booking.
Well, maybe in the first time of history, we've addressed all questions that have come from the audience and that I had. And we're down to about 5 minutes, and I know we have a prompt end time. So just any final thoughts on behalf of our panelists here, and then I'll say a few remarks, and I think we'll be finished. So,
You know, my comment is I'm excited about what central booking can do to this community and how it can affect, and I'm hoping phase 1 can turn into a phase 2, and the municipal courts will see how good it's working here, that they'll want to jump on and be part of this. Second, it just shows what collaboration, I can tell you just my summation, collaboration amongst all the groups and all the stakeholders, how things can better our criminal justice system. And I appreciate the bar bringing this to us, because this is something, collaboration with the bar, with all the stakeholders, we're able to communicate. And maybe, you know, again, we may have missed something that someone may have in the audience may have thought of now that we can maybe hopefully address before we get to the final programming.
Yeah, Judge, there's no pride in authorship. So as members of the bar, and we presented central booking before the CMBA, before, you know, during our COVID sessions. We did get good feedback. I remember getting some good feedback from Subodh Chandra, who had obviously lots of criminal justice experience, including having once been the city prosecutor, Cleveland city prosecutor. So we, as the judge said, we continue to welcome that. Again, I'm not being Pollyannish about the results we're going to see in the first month after implementation, but there's no question in our minds that we're going to see improved outcomes as a result of this, because we're making better decisions on the front end. We're having a first appearance incident report done immediately. We're having city prosecutor, county prosecutor collaborate pre-charge immediately, not done now. City and county pretrial services working together to eliminate duplication of efforts. And for the first time, Common Police Court applying its resources, its pretrial services resources, before they even have jurisdiction of the case. There's no question then we're going to have better outcomes, because we're going to make better decisions, because information will be more timely shared.
Just as a real quick finalization, I just want to say, I think you've heard the word a couple of times, inmate-centric. Every decision that we've made as a stakeholders group, and this is a lot of people that have been involved, the primary focus has been inmate care and inmate outcomes. Normalization of the process leads to better inmate behavior, makes everybody safer, and gets better outcomes in the long run, and that's what we're all looking for.
Judge Earley?
And collaboration is really important, and I think that we can't underscore, we can't underscore that. We have to, I can't put enough emphasis on the ability to collaborate, the ability for everyone to be at the table and to see how we all interconnect in the process has been very helpful. And it also has been helpful in terms of making people understand your place in the process, and then having other people help you do better, which is very important. So the collaboration that we've had with this group has been, you know, amazing, and something that, you know, I think going forward we'll continue to do to make this process even better.
So I am fond of quoting one of my law school professors, who always used to say the great thing about lawyers is they all seek to say something profound. The problem is they keep talking till they do. And I think with that in mind, everybody was very, very mindful of the time that we have here today, and very circumspect and open and honest about what they had to share. So I want to thank our panelists today for coming down, sharing the central booking process and the plans for the future with us. Thank you very much.
Join me in applauding the panel, please, as well as John Mitchell, our moderator. Thank you, everyone. And let me also invite you back on Tuesday, March 15th. We have another Hot Talk teed up where we're taking on the issue of the proposed name change to Cleveland Marshall College of Law. About 2 years ago, students came forward and asked the school to consider renaming the school. It's been under consideration and evaluation. Later this summer, the Board of Trustees for Cleveland State University will be taking up this issue. And we've got the folks that are in the know, both in terms of those who are supporting a name change and those who are opposing the name change. So please join us at noon on Tuesday, March 15th. Thanks again for joining us today. Thank you.